Hello everybody, and welcome to the Maryland Exclusive Buyer Representation Agreement class with the Brooks Group here at Keller Williams Realty. And to start off, I just wanted to say this is an important class. The buyer agreement is short at only 3 pages, but it's very important that you learn how to master delivering and explaining this agreement to your clients, because oftentimes new agents especially develop a lot of anxiety around the buyer agreement and getting a client to sign it, even though it's such a simple and natural thing that simply creates an agency relationship between yourself and your client. It is, in fact, what makes your client a client. Okay, so we're going to start off here looking at the Exclusive Buyer Representation Agreement, page 1 here. And it starts off relatively simple. We're going to start off with just the date, and it's the date that you're going to put this buyer agreement together and send it off to your buyer. Paragraph 1 is going to be your buyer's information, mailing address, telephone number, but specifically you've got to have a first and last name, and if you're going to have 2 buyers, they both need to be on there. Paragraph number 2, broker's information, office address, etc. Make sure all your information is complete. And in fact, it'd be best for you to set up your information as a template so you're not having to put in your same information every time you do a new buyer agreement. And moving along to paragraph 3, the buyer authorization. Paragraph 3 is really what establishes the scope of what it is that you're going to be doing. This is the purpose for having this agreement. Buyer authorization. Broker is hereby authorized by the undersigned buyer or the authorized representative of buyer or buyers to represent the buyer as the exclusive real estate broker in the acquisition of real property, which shall include cooperatives. As used in this agreement, acquisition of real property shall include any purchase or lease of property. The term seller shall include leaser. The term buyer shall include leasee. The buyer seeks the following type of property. And then you're going to have to put in there what type of property it is they seek. In our case here, by default, we always have in here Maryland residential real estate, but you've got to put something in there. Moving along to paragraph 4. And this is an important one, and it's one that I see the biggest number of mistakes when agents fill out their agency agreement. Buyer agency terms, rights of parties following expiration or termination of agreement. This agreement shall be effective on, then put in the starting date, and shall continue until midnight on, and then put in the ending date. Usually I put in 90 days, but you can put in as many days as you like. Unless terminated in accordance with the provisions of this section. Now this is very important because Maryland law says you have to have a beginning date and an ending date. There are no open buyer agreements or listing agreements. Now one other thing also, be very careful on that second date there, the ending date of your listing agreement, especially as you get closer to a calendar year and where that year rolls over into the next year, say 2016 rolling into an end date in 2017. A lot of times people by mistake keep the year the same year that they're in, and therefore it messes up your dates where it causes your ending date to be before your beginning date. So just pay attention to that. Okay. As required under Section 17-534, subsection B, paragraph 5 of the Maryland Real Estate Brokers Act, you guys like that? The parties agree to the following provisions of the termination of this agreement. And then put in whatever the terms are that you agree to terminate that agreement. In this case here, I like to put in there, agreed upon by both parties in writing or 3 days written notice from agent to buyer. Now, I like it to say agreed upon by both parties, meaning if they decide they want to terminate this agreement, I want to have the final say whether or not I'm going to release them, which is why it has to be agreed on by both parties. Or the next section allows me to unilaterally cancel it myself if I give them 3 days notice. Okay. An expiration or termination of this agreement by buyer or broker shall be subject to the provisions of paragraph 7 of this agreement. And paragraph 7 of this agreement shall survive the expiration or termination of this agreement. Notwithstanding the rights of the parties to terminate this agreement as provided herein, broker, in broker's sole and absolute discretion, may terminate this agreement at any time and effective immediately in the event the buyer provides any false information or misrepresents any fact to broker or other third party. This means that if your buyer lies to the listing agent, any of these third part, not the listing agent, but the well, it could be the listing agent, or it could be the lender, or any other person involved in the transaction, then we have the ability to withdraw immediately. If a contract of sale entered into by buyer during the buyer agency term, which provides for settlement to occur after the expiration of the buyer agency term, this agreement shall be automatically extended until settlement has occurred or until the contract of sale is released in writing by the parties. So what that means is, let's say we have a 90-day buyer agreement. If we go under contract after, say, 80 days, but the settlement isn't for another 45 days after that, this buyer agreement automatically extends until settlement, which is great. Moving along. Paragraph 5. Buyer responsibilities. Exclusive relationship with broker. Buyer will work exclusively with broker during the term of this relationship. This means that the buyer can't go out and use 3 other different buyer agents to find them the perfect property. I see buyers wanting to do this more when it comes to investor buyers that just don't know how it works. I see a lot of them try and do that. But under this agreement, they have to work with you exclusively. Subparagraph B. Financial information. Buyer will furnish broker with necessary financial and personal information to reasonably establish buyer's ability to purchase a property. This means that the buyer is agreeing to turn over their information and get pre-qualified. Basically, they have to be able to show to us that they have the ability to purchase the property. Signs or advertisements for property. If buyer sees any signs or advertisements for properties being offered for sale, buyer will not contact the seller or agent of the seller, but will first contact a broker named herein, who will provide information about the properties and then make arrangements to see them. This means that the buyer is agreeing not to call the seller off of signs or go in and see open houses without notifying you first, so we have a chance to let that other agent know. This is for the purpose of not causing any confusion with procuring costs, because that can be a hassle. And finally, D, new home builders and open houses. We already talked about open houses, but new home builders, in order to avoid the possibility of confusion over the agency relationship and misunderstandings about liability for compensation, buyer agrees not to make a first visit to any new home builder's model, nor contact any other agents representing sellers or new homes without being accompanied by broker. Buyer agrees not to enter open house properties unless accompanied by broker or after had broker make arrangements with the listing broker. So anyway, like we said, they're agreeing not to go into new construction or open houses without us making the arrangement first. Because a new home construction builder, if we don't call and register that buyer ahead of time, and if that buyer goes without us, that new home builder will not pay us. And moving along to paragraph 6. Now those paragraph 5, those were the buyer's responsibilities, what they've agreed to do for us, and now paragraph 6 will be our responsibilities to them. The agent and broker agree to locate real property, use professional knowledge and skills to locate and present real property, which is available for purchase and suitable to the buyer's needs. So that says we are going to search for properties for them. We're not just going to sit there and wait for them to bring properties to us, but we're going to locate property for them. And finally, B, assist the buyer. Assist buyer through the process of property acquisition. We're going to help them with the whole entire process, where it's putting an offer together, the home inspection, etc. And C, represent buyer's interests. Represent the interests of the buyer in all negotiations and transactions regarding the acquisition of real property. Paragraph 7, broker's compensation. The amount of broker compensation is not prescribed by law or established by any membership organization with which broker is affiliated. And paragraph A here, compensation to be paid by buyer. In the event of a sale or lease, the compensation to be paid by buyer to broker shall be, and this here, you get to put what the compensation is that you're requiring. In this case here, I have in here written, paid by seller per MRAS plus admin fee of $4.95 from buyer. If buyer breaches this agreement, 3% of the purchase price paid by buyer. Now, I have to point out in this case that compensation that's written in there is poorly worded and is actually weak if there were any sort of disagreement here. It should actually say 3% of the sale price, or some sort of flat fee in case there's a breach, so that this can be enforceable. Because just saying 3% of purchase price paid by buyer, well, what if there was a breach and we weren't actually involved with a house under contract? Then what is 3%? So that probably wouldn't be enforceable. So be very specific in that section there. Okay, the compensation shall be deemed to have been earned by broker and shall be due and payable to broker if 1. During the term of this agreement or any extension thereof, the buyer or any person or entity acting on buyer's behalf executes a written agreement to purchase or lease any property through the efforts of anyone including the buyer, in which the buyer within 72 hours thereof shall furnish to broker a copy of such written agreement. So this means we're entitled to the commission if the buyer puts a property under contract, whether through you or on their own somewhere. You're entitled to a commission on that property from the time it goes under contract. And you'll see here further on down that just waiting until settlement is a courtesy but not required. And finally, if during the period of 180 days, now you can put any period you like in there. 180 is a little bit on the long end. I've seen a lot of times agents will put 90 days in there. I like it to be 180 days just in case so these buyers don't get any funny ideas. This is a non-circumvention clause here. Okay, and once again, if during the period of 180 days following the expiration or termination of this agreement, buyer executes a written agreement to purchase or lease any property that the buyer inspected, made inquiry about, or negotiated to purchase during the term of this agreement or any extension thereof, in which event buyer within 72 hours thereof shall furnish broker a copy of such written agreement. This means that even after my broker agreement expires, if they purchase a home that we showed them, they made inquiry about, etc., for 180 days after the expiration of this agreement, we still are entitled to compensation on that property. Like I say, this is a non-circumvention clause, basically, so that they can't just cancel the agreement with you and then go deal directly with a seller or listing agent. And 2, buyer defaults or voluntarily agrees to terminate a sale. This means that, let's say a buyer goes under contract with a property, everything's going fine, their financing is qualified, and they just decide on a whim or for any reason whatsoever that they want to withdraw from purchasing that property. Now, this doesn't count for the home inspections, etc., but if they just want to withdraw for whatever reason, you're still entitled to a commission on the sale. Now, 3, buyer breaches this agreement. So you're entitled to the commission on the sale if the buyer breaches this agreement for whatever reason. And I could see, say, paragraph 5, the buyer responsibilities, or some of these other things that would entitle you to a commission. The compensation due broker shall be paid at settlement as a convenience to buyer. Buyer acknowledges and agrees that settlement on the property shall not be a condition precedent to buyer's obligation to broker as herein provided. So that means that settlement itself is not a condition for you earning the commission. Them going under contract is. If broker prevails in any action brought to obtain payment to the compensation, broker shall also be entitled to recover in such action broker's reasonable attorney's fees and court costs. So that means if we have to sue a client to get a commission, then we're also going to be entitled to reasonable attorney's fees that it cost to bring that action. Buyer shall have no, and that's in the event that you win, of course, that lawsuit. If you lose, and that's the end of it. Agreement with any other licensed real estate broker following the expiration of this agreement or any extension thereof, buyer shall have no obligation to pay the compensation of broker if buyer enters into a buyer agency agreement with any other licensed real estate broker following the expiration of this agreement or any extension thereof, or following the termination of this agreement as herein provided, unless such termination by buyer shall have been made for the purpose of avoiding the obligation of buyer to pay the compensation to broker. Okay, section B, fee paid by seller. Broker is authorized to receive compensation from the listing broker seller. Compensation may be offered from the listing broker to broker through the multiple listing service or from seller as negotiated by broker and seller for real property which is not listed with another broker. The amount of compensation received by broker from a listing broker or from a seller shall be credited against the compensation agreed upon in paragraph 7A. Buyer shall be obligated to pay any difference between the amount owed and the amount paid by the listing broker or seller. In the event the amount of compensation offered by the listing broker/seller is greater than that specified in paragraph 7A, buyer authorizes broker to receive such compensation and to retain any such additional compensation without proration or rebate to buyer. The amount of any such payment made by listing broker or seller shall be with the seller's and buyer's prior knowledge and consent and shall in no way affect the action of the broker to act on behalf of the buyer in the transaction. So if in paragraph 7 above you gave, say, a specific number and it was, let's say you said 3% of the total sales price, and in the MLS the seller only offered 2.5%, and the buyer agreed to that, then they'd be obligated to pay you the extra 0.5% out of their side of the transaction. Moving on to paragraph 8, disclaimer and limitations. A. Limitations of broker's ability. Buyer acknowledges that broker is being retained solely as a real estate agent and not as an attorney, tax advisor, lender, appraiser, surveyor, structural engineer, certified home inspector, or other professional service provider. Buyer has been advised to seek professional advice for legal, tax, and other matters. So this lets them know we aren't all of those things, even though sometimes it can seem like we are. We have to be very careful not to give legal advice, tax advice, etc. And, of course, refer them to the professional that they may need the advice from, such as an attorney, home inspector, etc. B. Representation of other buyers. Buyer acknowledges that broker may represent other buyers and that other potential buyers may consider, make offers on, or purchase properties through broker. Buyer consents to broker's representation of other buyers before, during, and after the expiration of this agreement. This lets them know, even though we have an exclusive buyer representation agreement with them, they aren't exclusive buyers working with us. And C. Subsequent offers. Upon entering into a contract of sale or lease pursuant to this buyer agency agreement, broker shall have no further obligation hereunder to procure any subsequent properties for buyer. So once we've put them under contract, we have no more obligation to procure further properties. Ministerial Acts. Buyer hereby consents to and authorizes broker and broker's agents to provide ministerial acts as defined by law on behalf of buyer to third persons in connection with the purchase of the property. Third persons may be, say, the listing agent, maybe the lender, etc. It just allows us to do ministerial acts, which are, say, simple paperwork, things like that. Confidentiality of offers. Buyer acknowledges the possibility that sellers or sellers' representatives may not treat the existence, terms, or conditions of the buyer's offer as confidential information. Paragraph 9, and this is a funny one because this exclusive buyer representation agreement form has not caught up with the recent changes as of October 2016. Agency disclosure. Buyer acknowledges receipt of understanding whom real estate agents represent. This has been superseded with new law that says that if they're signing this buyer representation agency agreement, then we no longer need an understanding agency disclosure. Paragraph 10. Intra-company agent representation. When the buyer and seller are each represented by sales associates of the broker is a dual agent. Dual agency is permitted only when disclosed and with the knowledge and written consent of both parties. However, the sales associate assigned by the broker as an intra-company agent may continue to provide the same services that a buyer's agent can provide on a property listed with another broker. So what that means is the broker's the dual agent, and you still represent that buyer. Another agent in the office represents the seller. In the event buyer elects to consent to dual agency, buyer agrees to sign the required consent for dual agency form as published by the Maryland Real Estate Commission. In the event buyer elects not to consent to dual agency, buyer acknowledges and agrees that buyer will not be advised or shown properties listed by broker and will only be shown properties listed by other real estate brokers. So what that means, if they do not want to consent to dual agency, we cannot show them properties listed by agents within our own office. We can show them everything else, but just not properties listed by ourselves or agents within our own office. And finally, paragraph 11, legal construction. This agreement is binding upon the parties hereto and their personal representatives, successors, heirs, and assigns. In this agreement, if this agreement is signed by more than one person, it shall constitute the joint and several obligations of each. That means they're both obligated to it together and they're obligated individually, no matter what happens with the other. This agreement contains the entire agreement of the parties and cannot be changed except by the written agreement of the parties hereto. Buyer warrants that there are no other existing agreements or conditions other than as set forth herein. This is a legally binding agreement. If not understood, seek competent legal, tax, and other professional advice. Buyer has not relied upon any statement or representation of broker except as set forth in this agreement. This agreement shall survive execution and delivery of the deed and shall not be merged therein. This agreement shall be interpreted and construed in accordance with the laws of the state of Maryland. So paragraph 11 establishes the jurisdiction and the legal obligations of in case there is some sort of dispute in this agreement. And finally, paragraph 12, addenda. The addenda marked below, which are hereby attached, are made a part of this agreement. Understanding agency or consent for dual agency, check those if they're included. And if there are any other special conditions to your agreement with your buyers, then it'll go in the box below. And finally, they're going to sign it and we're going to sign it. Both parties need to sign it for it to be valid, and a copy has to be delivered to both parties. Now, when we use .loop or any other electronic signature platform, generally that will provide a signed copy to both parties, so you're taken care of as far as that goes. So just to reiterate, I want you to remember, again, back to paragraph 4, the start and end date must be filled in, and they must be filled in correctly. Pay attention especially to that second date for errors. I've actually seen disputes before arise over broker agreements where one agent had picked up a new client, a previous agent at a different brokerage claimed that they had a exclusive buyer agreement with that particular client. They sent over the buyer agreement, and that second date was messed up and was from the year before because they didn't check it, and therefore it was no good, and they lost out on a bunch of money for that. So just make sure and check those dates to make sure they're correct. Also, make sure you must have a termination provision. So make sure you have a termination provision there so that we're in compliance with the law. And finally, your buyer agreement creates your agency relationship. Remember that. So make sure you provide a whole bunch of value when you're picking up your client so that the buyer agreement itself is just something nice and easy that creates that agency relationship, because they want to be working with you. They want you to be their agent, and this is the tool and the mechanism with which we do that. Anyway, I hope that you got a lot out of this class. I hope you have a better understanding of the buyer agreement itself. You should be able to go now and answer any questions that your buyer may have. If they're a little reluctant about the buyer agreement, now you should be able to have a full understanding of what's in it, what it means, what it does for them, and how it should benefit everybody involved. I want to thank everybody for attending this training session. Look forward to more sessions with you in the future, and I hope you have a profitable week. Thank you.